and if released on bond and the burning of the schools is likely to be escalated. Equally, I consider that the decision of Johnson that we must interpret the Constitution of 2010. Now, I think I should go to the last motions. You get a copy and go through it. The public interest is done for the Kabali, and the public interest on the other side. That no one will be punished without the benefit of due process. In incarcerations before trial, when the outcome of the case is yet to be determined, cuts against this principle. The need for bail is to ensure that they are public. So the court said, generally in principle, and because of the assumption that a person charged with criminal offense is in unless it is shown by prosecution that there are substantial grounds to be leaving from the U.S. and Canada. The United States in the case of Stanton versus Boyd, U.S. 1951 are the case hampered preparations of a defense and serves to prevent the infliction of punishment prior to conviction. The court defined excessive as pay set at a figure at the presence of the accused. Significantly, the court parliamentary is submitted to the prosecutor. This will enable the defense to interrogate facts as to its veracity. Counsel says he is ready to deposit a sum of 5,000 as cash bail on behalf of the accused person. On the other hand, the prosecutor opposed the release of the accused on the ground that there is a wave of school fire among the students' institutions. The trajectory of their demonstration is to burn down schools, and if released on bond, and the burning of the schools is likely to be escalated. Equally, I consider that the decision of Johnson where the court said that liberty is precious, and also that we must interpret the Constitution to enhance the rights of the accused persons. Now, I think I should go to the last motions. You get a copy and go through it. The public interest is done for the Kabali. The granting of bail entails the striking of a balance of proportionality in considering the rights to the applicant who is presumed innocent at this point on one hand, and the public interest on the other side. The cornerstone of the justice system is that no one will be punished without the benefit of due process. In incarcerations before trial, when the outcome of the case is yet to be determined, cuts against this principle. The need for bail is to ensure that the accused person will appear for trial and not to corrupt the legal processes. Anything more is excessive and positive. Additionally, in the same vein, Nana versus Republic. So the court said, generally in principle, and because of the assumption that the person charged with criminal offense is innocent until he is proved guilty, an accused person who has not been tried should be granted bail unless it is shown by prosecution that there are substantial grounds to believing that the accused will fail to turn up at the trial or surrender. Following from the US and Canada, the 18th Amendment of the American Constitution in the US, which prohibits the use of excessive bail, the Supreme Court of the United States in the case of Stanton versus Boyd, US, 1951, added this to say, provided the guidelines in assessing whether bail is excessive, starting from the premises that the additional right to freedom before conviction permits unhampered preparations of a defense and serves to prevent the infliction of punishment prior to conviction. The court defined excessive as bail set at a figure higher than an amount reasonably calculated to assure the presence of the accused. Significantly, the court tied the question of whether bail determination is excessive to the purpose of bail. As the court explained, the purpose of bail is to help assure the presence of the defendant at the subsequent proceedings. Since the freedom of bail is limited, the filing of bail for any individual defendant must be based upon standards relevant to the purpose of assuring the presence of the accused. A similar proposition was held in the case of Grievin versus Illinois, US 1956, where it said there can be no equal justice where the trial of a man gets depends on the amount of money he has. Now, the submissions by the defense together with the prosecution. Taking the undisputed facts of the case at the base value, the court takes judicial notice by dint of section 60, subsection 1(4) of the Evidence Act, chapter 8 laws of Kenya, that the trending issue in the Republic right now is the funding of the university's education. The court is aligned with the fact that new higher education funding model was unveiled by President Ruto on May 3, 2023, and it aims to address the challenges encountered by public universities and technical and vocational education institutions due to massive enrollment and inadequate funding. This new funding framework replaces the differential unit costs previously used to finance universities. This model prioritizes a student's financial need and separates placement from funding. Under this model, universities and TVETs institutions will no longer receive block funding of the student. Is that the model categorizes students in various bands, and the conversation in respect to this is ongoing. Now, this scenario alone is evidence enough that unless the students are funded, they are unable to privately fund their education. And so that by extension of this narration, when students appear in a court of law as suspects, the general method of approach in considering their liberty will of course work out excessive cash flow. So the review of that and my analysis, I admit the accused to a cash payment of 5,000 shillings. Further, the state to supply the accused with the statements and all other documentations to be relied on at the trial. We have
which the accused person has begun honoring. Your Honor, I don't know.